All right, hello and welcome to this evidence video capsule. This is the third and final capsule on the concept of corroboration. And this one is going to look at how the term corroboration is most commonly used today, which is not about legal corroboration, as that term was discussed when I looked at corroboration as a statutory condition. It's actually used in connection with something called a Vetrovec warning, which is named after the 1982 decision in which the court transformed the law of corroboration into a less onerous requirement, and that was, of course, the decision of the Queen and Vetrovec. I'm going to discuss how these Vetrovec warnings change the historical approach to corroboration and how they are addressed in law today. If you are new to the concept of corroboration, I highly recommend you first going back and listening to part 1 of the series, in which I explain the different ways in which the concept of corroboration is used. So let me stress from the outset, what I'm talking about here applies only in criminal cases in the situation in which corroboration is used as a common law concept. All other aspects of corroboration are not my concern in this video. 3 things on the menu today. First, what did the case of Vetrovec actually accomplish? Second, I'll look at when is a Vetrovec warning actually required. And then third, I'll look at what has to be in a Vetrovec warning, or as well as sort of examining what is the point of a Vetrovec warning altogether. So let's look at a standard case in which a Vetrovec warning tends to be required, but I want to go back a little bit in time and talk about how this particular problem was dealt with at common law. So to make it clear, it's Johnny here who is charged with murdering Bob. Bob is the victim, Bob is now dead, but Johnny and Stan were what would be called at common law our accomplices. They've decided to go in it together, and the Crown theory is that Johnny and Stan planned it together, but Johnny was the lead guy. So whatever reason, the Crown makes a deal with Stan and says, you testify against Johnny and we will reduce or drop your charges as a result. So this is a classic scenario in which Stan is testifying against Johnny, but let's be clear. I hope you can recognize Stan has a real incentive to implicate Johnny. And that is known at common law to be what we call a problematic witness. We are concerned about the evidence that Stan is giving because Stan could be lying. Stan has every reason in the world to lie in this situation, and therefore his evidence is what we call as suspect. Now, at common law, the system of corroboration, as I mentioned in capsule number 1, was very, very complex. Essentially, there were all sorts of rules that impose evidentiary requirements on the Crown in order to get Johnny convicted, right? And if the Crown could not meet those rules, then Johnny, it was impossible to convict Johnny at all. And these got incredibly technical. If you ever want to go read some interesting cases that will drive you crazy, go look at the corroboration cases through the 60s and 70s. They're really eye-opening. Because essentially what happened is the corroboration became incredibly technical. It wasn't so much that we were just concerned about Stan's evidence. They started to impose very technical requirements. In essence, Stan's evidence had to be corroborated by independent evidence on various aspects of his testimony, and it had to be done so independently. It was very, very difficult to make sure that corroboration was actually met, and to make it clearer, it was very difficult even for a judge to get the warning right. Again, I've read some of these cases in the 60s and 70s, and let me tell you, they're very difficult to reconcile. And this is what the case of Vetrovec is actually all about. In Vetrovec, essentially Vetrovec is charged, there's an accomplice, like Stan, and essentially the issue isn't really whether Vetrovec is guilty or innocent, the question is whether or not the technical requirements of corroboration were met, and there were all sorts of arguments that the particular warning that was given and the particular direction did not meet the technical requirements of corroboration, which I won't bore you with because they were too technical to even be bothered with. The real question is, what did Vetrovec do? So Vetrovec was incredibly important for 3 reasons. It made 3 major changes to the law. First and foremost, it eliminated corroboration as a technical requirement. Now that's a pretty big change. So no longer do you have to meet this technical series of checkpoints, and when you couldn't meet them, the judge could take the case away from the jury. No more. Okay? So corroboration is no longer a mandatory element of a case, and it's not a matter to take the case from the jury. However, the court didn't get rid of the whole idea altogether. And that's why when we talk about corroboration today, we are talking no longer about evidentiary requirements, but talking about a clear, sharp warning. That is a direct result of what happened in Vetrovec. So in some cases, the judge recognized that the concerns about corroboration, the worry about Stan as a witness, requires a clear, sharp warning that it would be dangerous to convict if evidence uncorroborated. So that's number one. But the court went even further. They reduced the need for corroboration altogether. Essentially, Justice Dixon said, look, in the old days, corroboration was required every time you had a child on the stand, every time you had an accomplice on the stand, every time a witness was disreputable. The court didn't precisely spell out when corroboration was required, but made it clear that it was a lot fewer. Essentially, it was a decision for the judge, and whether or not the judge had a concern, and let me stress that in Vetrovec itself, that concern wasn't as spelled out as it probably could be, but subsequent cases I'm going to talk about flesh that out. But clearly, corroboration is not as important as it used to be. And I should stress that one of the other impacts of Vetrovec that's really important and often overlooked is that after Vetrovec, the feds got a hold of it and said, well, wait a minute. If the courts are saying that corroboration is less important, maybe we should get rid of some of the statutory requirements for corroboration that we have. And they did. That's when they eliminated mandatory corroboration requirements in sexual cases, mandatory corroboration requirements for children, etc. So essentially, Vetrovec was important both in reforming the common law and also in providing an impetus to the federal government to make necessary changes to the statutory law of corroboration. But here's the third big one, because if you think about what number one did, yes, it said we don't need corroboration as a technical concept anymore. If you go back and look at what that first qualification was, it said that in some cases, a clear, sharp warning is requirement to show that the witness's evidence is corroborated. Remember that? It'll be dangerous to convict on uncorroborated evidence. The court went on to say, well, that wouldn't fix things. We'd still have appeal after appeal if the concept of corroboration was still restricted to its early days of independent evidence on a material concept, and that's very tightly litigated as to what is a material piece of evidence. No more of that. No more need to connect each piece of evidence to every accused in a very technical way. All there has to be is, when you are talking about corroborating evidence, is there independent supporting evidence, and I will go through in a moment what's required for this evidence, and does it generally strengthen our belief that the witness is telling the truth? And I think this was probably the most important development coming out of Vetrovec. Instead of maintaining a very technical legal concept of corroboration, the court adopted a common sense view of what can be considered corroborating evidence. If there is evidence that makes us feel comfortable with the idea that this witness is telling the truth because it connects to an important part of his testimony or her testimony, that's good enough. And that was probably the most significant aspect of the Vetrovec decision. So as a result of Vetrovec, we have two important things left. In fact, this is all, leaving aside statutory corroboration, which I'm not talking about here, all that when we're talking about corroboration, we're really talking about two questions. Number one, when does a warning have to be given? That's the first question. Is a warning needed at all? And number two, if a warning is given, what should be in it? If you understand these 2 points, then that's all you really need to know about corroboration in the criminal context. But before going forward, it's worth thinking about one last thing. In what situations is a warning required? The answer to that has now been expanded upon since Vetrovec. Vetrovec was a little unclear. It just said if the judge is of the reason to believe that the witness is credible, there's no warning required. But that's clearly not good enough. We have to think more about the principle and the idea of why we give warnings at all. And probably the most important case to be decided on Vetrovec warnings since Vetrovec is a case called Kayla from the Supreme Court. And in Kayla, I think Justice Fish really nicely set out the principles upon which corroboration is based. And here's what they are. Instructions required not because jurors are stupid, but because they might be uninformed. And I think this is the key. It's meant to bring home the accumulated wisdom of the law's experience. So judges have more of an experience with unsavory witnesses. And the fact that you bring in a witness who might sound very persuasive and credible is not good enough. Essentially, what we are looking at is this right here. Are there reasons to be skeptical? And are those reasons the type of things that jurors would not naturally be aware of? Okay? If you have those two conditions, you probably have the need for a Vetrovec warning. And in fact, the jurisprudence that's come forward since has been based on these two specific criteria. So with that principle in mind, let's dig into when is a warning required. Well, first and foremost, Vetrovec warnings only operate against the Crown. They are designed to uphold the presumption of innocence, and they're designed to ensure that wrongful convictions don't take place. So where a defense witness is, shady and giving shady evidence on behalf of the defense, they don't get a Vetrovec warning. And one of the reasons for that is because of the way the burden of proof operates. Witnesses testifying on behalf of the defense are not part of a package of evidence that has to be proven guilty beyond a reasonable doubt. All they have to do is, at best, raise a reasonable doubt. So we do not give Vetrovec warnings against defense witnesses. Number two. This is kind of funny. If you go back and look at Vetrovec makes it very clear that the old categories of witnesses that require Vetrovec warnings is out the window. We're not going to just give to every disreputable witness. We're not going to give to every accomplice of witness. Okay? And that's made very clear that the judge has to measure the individual witness. Well, that's true. The categories of witnesses no longer exist, and what I mean by that is the fact that a witness is an accomplice doesn't automatically mean you have to give a corroboration warning. But if you read Kella carefully, the excerpt that I gave you, I'm telling you categories of witnesses are incredibly important. And the reason why categories of witnesses are important is because what we're looking for is the accumulated experience of judges. And how do we get accumulated experience of judges? Well, we look at the category of the witness. If the witness is the type of witness that typically causes problems in the judicial system, you're more likely to get a warning. So you can go back and read through tons of corroboration jurisprudence after 1982, including Vetrovec, that makes it very clear that the categories are dead, and I'm telling you the categories are alive. They're alive indirectly, if not directly. And what I mean by that is it's not automatic, but it's still a very strong indicator. And every case I've read over the last 5 years really looks at the category of witness and, do they have the type of historical problems we're concerned with. So it's a strongly discretionary decision, which means that the judge's decision ultimately to give one or not give one is a big factor on appeal, where this actually comes up. So if the trial judge decides to give one, 9 times out of 10, the judge's decision is going to be kept up. And if the trial judge decides not to give one, again, 9 times out of 10, that's not going to go anywhere on appeal. However, the courts of appeal have reserved the power for that small category of cases in which a warning is mandatory. And in a subsequent supplemental capsule, I'm going to talk about jailhouse informants, which are a particularly troublesome category of witness in which a warning is almost inevitable. You have to give just about a warning in those cases because of the risks posed by that sort of evidence. So it's a highly discretionary decision, but some cases the courts will intervene and say, no, a warning is mandatory. 2 main factors will be balanced. I've already referred to this one. Are there historical factors that really make us worry about this evidence? But the second is the importance of the evidence to the case. You don't get a clear, sharp warning where the witness, even though the witness has some problems, let's say you call an accomplice, but they only provide marginal testimony, let's say about how you got the getaway car, that doesn't get a clear, sharp warning. Generally speaking, the centrality of the evidence is the second factor that a judge has to consider. And of course, just a reminder that the purpose of the warning is to alert the jury to dangers or weaknesses that jurors would not otherwise see. So it's not enough that the juror has problems, right? There have been many cases where a juror's problems have been fully illustrated. It's been very clear that, one is like they said different things on different occasions. Well, those dangers and weaknesses are very evident. So the question really for the judge is, well, is this the type of thing that's not evident? And by the way, I should add on this is really important. it's not enough for defense counsel to question on these things, right? The idea is that the defense counsel will always question a jailhouse informant on the weaknesses in their evidence, but that's not enough. Where the dangers or weaknesses are thought to be outside of the ordinary, the judge should provide judicial commentary, because ultimately it's the judicial instruction that jurors have to follow, not the defense counsel's address, which is going to be contradicted by the Crown. So it's very important to recognize that the key is whether the risks are evident or not whether or not they've been pointed out by the defense. So let's look now what should be in the warning, our last particular factor. And again, the judges have made it very clear that this is a discretionary test, and that individual judges have a lot of discretion in how to craft their warning. But here's what they look for. Number one, you got to single out the problematic evidence. So A is the problematic witness. Has A's evidence been separated and treated to a corroboration warning? That's the first question that needs to be asked. Well, I said otherwise earlier that this is about, providing the jury with context about why this evidence might be problematic, and that's what the second part of the warning is. You've got to explain to the juror the historical factors that make us be cautious about accepting evidence from witnesses of these types. You then go on to talk about the dangers of convicting without confirmatory evidence, which is just another word for corroborating evidence. If you can't find this sort of confirmatory evidence that makes this more likely to be comfortable with the witness's evidence, then the jury should not convict. That's the basic idea. You should be cautious about convicting, even though if you haven't found this particular evidence. And let me just say, for the record, judges have to leave it to the jury to convict, even if there's no confirmatory evidence. It's up to the jury ultimately to make that decision. And it's beyond the context of this capsule, but that's a really interesting, controversial topic. Some legal scholars have suggested that jurors should no longer be instructed to that effect. Jurors should not be instructed that they can convict even without confirmatory evidence, on the basis that some of this evidence is so problematic that why should jurors actually convict if they can't find any evidence to confirm what a problematic witness has said? But that is not the law right now. The law is right now that it's up to jurors to decide whether or not to convict. And that's the nature of the test. Jurors should look for evidence from another source that tends to show that the untrustworthy, I shouldn't put untrustworthy, it should be untrustworthy or problematic. To give you an example of why I say problematic versus untrustworthy, ID evidence is a particularly problematic area here, where you have evidence from an ID witness where they tend to identify somebody from afar, but it's not the best ID. That's not an untrustworthy witness. They're not lying. Problematic. They're not necessarily reliable enough to give the evidence that they're giving. And finally, the judge can provide examples of potentially confirmatory evidence. They can't tell jurors that this does confirm, but they can provide a list. This is another controversial area because defense counsel are often worried that this re-emphasizes why the accused is guilty. So there's a worry about this list of potentially confirmatory evidence, but there's no question that judges should, they don't absolutely have to, but should provide examples of potentially confirmatory evidence which the jury can find confirms or not. And to wrap this up, what should jurors look for? Well, when they're looking at confirmatory evidence, that's the focus. They are not allowed to use tainted evidence, right? So where the detail in a witness's testimony is provided by the police. So for example, let's make this much more concrete. So witness A is the problematic witness and says, well, I know he did it because I saw the gun and it was a .38 Magnum or whatever. That's what the gun was. So I know it's true. If that detail about the .38 Magnum, normally you'd say, well, that's corroborated because then a .38 was found in the accused's apartment. And that's corroborating evidence. The gun matches the gun. Well, if there's evidence to show that that detail about the .38 was provided by police, then that's not good corroborating evidence for reasons you can hopefully see, quite evidently. So it's got to be untainted evidence. And evidence that doesn't make it more likely that the witness evidence is true cannot do this. And there's some funny cases where judges have given examples of confirmatory evidence, things that are matchable to the witness's evidence, but don't actually make it more likely that the evidence is true. They're just incidental details that don't actually give you any reason to believe that what's being said is true. It has to connect to a material part of the implicating testimony. It's not like, I'll give you an example of this. Let's say A, just change the example of the 38. I'll give you an example of an incidental detail. A says, I went to the diner that day, and then the next, an hour later, I met with Johnny, and Johnny, went on to kill this guy. Okay, if he can provide a receipt saying he went to the diner, that's corroborating evidence of his story, but not corroborating of anything that's material to his story. That's just an incidental detail that does absolutely nothing, and that is not a confirmatory type of evidence that can be used by jurors to convict. So that, in a nutshell, is what we're looking at with corroboration. It is a warning required, and what should be in the warning, and understanding, obviously, the underlying basis of what corroboration is designed to do should help you understand when a warning is required and what should actually be in it. I hope that was of some use to you in understanding the concept of corroboration. Have a great day.
To learn more about this topic, you might want to check out my book, The Law of Witnesses and Evidence in Canada, published by Thomson Reuters. This book covers every topic involving the law of evidence and also how witnesses come before courts and tribunals in criminal, civil, and administrative proceedings. To learn more, you can check out my website at petersankoff.com.